Thank you all for being here. We are here to address any questions in relation to this morning's issuance of a presentment by a Philadelphia grand jury that has recommended the bringing of perjury and false swearing in official matters charges against 3 Philadelphia former police detectives. All 3 of them are retired at this time. Those 3 detectives are homicide detectives Manuel Santiago, Martin Devlin, and Frank Yastrzemski. Some of these names may be familiar to some of you from other cases. And the charges in this case relate directly to words that they stated, things that they said in and out of court in 2016 and 2017, long after the original and wrongful conviction of an innocent man, Anthony Wright. The 31st Philadelphia County Investigating Grand Jury has heard evidence and has issued a presentment in which they recommend criminal prosecution of 3 former Philadelphia police homicide detectives for lying in 2016, both in and out of court, about their on-duty roles in the investigation, interrogation, and wrongful conviction of an innocent man, Anthony Wright, which occurred in 1993. Eventually, Mr. Wright's innocence was proven by DNA evidence that also identified the actual perpetrator of the crime, a man named Ronnie Bird, whose DNA was already in a DNA database as a result of other crime. Wright's wrongful conviction was overturned, but incredibly, the Philadelphia DA's office under former DA Seth Williams retried Anthony Wright despite irrefutable science establishing Wright's innocence. These 3 detectives, Santiago, Devlin, and Yastrzemski, provided sworn testimony and documentation during the 2016 retrial, where Mr. Wright was acquitted in about an hour, and during Wright's subsequent and successful civil rights lawsuit. Some of the sworn testimony and documentation that these detectives provided is the basis for these criminal charges. A grand jury presentment was accepted by the Court of Common Pleas and unsealed today. Manuel Santiago, Marty Devlin, and Frank Yastrzemski are the 3 detectives who are now charged with multiple counts of perjury, a 3rd-degree felony crime, and false swearing in official matters, a 2nd-degree misdemeanor crime. They are expected to turn themselves in. In fact, it's my understanding they're turning themselves in right now as we speak at the 15th District with the assistance of their criminal defense attorneys. According to the presentment, Wright was convicted in 1993 for the 1991 rape and murder of 77-year-old Louise Talley on the strength of a coerced false confession, which is referred to as the Santiago Devlin confession, and false testimony from Yastrzemski about the location of clothing he falsely claimed was found during a search of Wright's bedroom, but was actually found in the home of the victim. According to the presentment, Wright, who was then 20 years old, repeatedly told detectives he had no involvement in the crime, he had no knowledge of the crime. He spent hours repeatedly crying for his mother, whom he could hear outside the interrogation room calling out to him. Less than 24 hours after discovering Mrs. Talley's body, Detectives Santiago and Devlin coerced Wright into initialing and signing a false confession to a crime that Wright did not commit, the details of which he could not have known and did not know. Nevertheless, those details are contained in that confession. Wright's interrogation by Santiago and Devlin was not recorded or taped. The grand jury further concluded that the detectives deployed unlawful tactics to coerce Wright into signing the false confession, including by threatening to, and this is a paraphrase, but it's essentially a quote, pull his eyes out and skull F him, falsely stating that Wright could go home if he signed the Santiago Devlin confession, and directing Wright to sign and initial the confession to create the appearance that he had actually read and verified its contents, while they prevented him from reading its contents. According to the presentment, Wright purportedly confessed that he was wearing a black Chicago Bulls sweatshirt, a pair of blue jeans, and a pair of black Fila sneakers while he committed the rape and murder. Former Detective Yastrzemski later testified falsely under oath that during the search of Wright's home, he and two other detectives uncovered the sneakers and jeans in a pile of clothes on the floor of Wright's bedroom and the Chicago Bulls sweatshirt under Wright's mattress. But decades later, DNA testing proved that another man, a man by the name of Ronnie Bird, who lived near the victim's home, in fact about a mile from the victim's home, and who was by then deceased, had raped and murdered Mrs. Talley. I don't want you to miss that point. In a universe of DNA, the DNA that was taken from the body of this victim at a time when science has improved, in the universe of DNA that's in DNA databases, comes back as identifying a man who's in the DNA database for criminal activity and lives a mile from the victim. It is beyond extraordinary. It's not that extraordinary to find DNA that exonerates a defendant, even one who sat in jail for decades. But for that DNA to come back and identify by name the actual perpetrator, an individual who lives a mile away, who's in that database for crime, for it to do that, and then to have a district attorney's office turn around and say, I guess we'll try Mr. Wright again. I guess we'll put these witnesses on the stand again, is an absolute outrage. The clothing that Wright's false confession stated he wore during the crime, and that Yastrzemski later falsely claimed he found during a search of Wright's home, yielded what they call wearer DNA from Talley. In other words, the locations, the types of DNA that were recovered, the way it was recovered, indicated that this is DNA that a person wearing the clothing would leave. This clothing was worn by Mrs. Talley, not Mr. Wright. Arguably, the statute of limitations for several possible crimes committed by these detectives during the 1991 investigation and the 1993 trial may have expired. As a result, the 31st investigating grand jury instead reviewed the detectives' conduct during the 2016 retrial of Wright and the 2017 depositions that took place during the civil lawsuit Mr. Wright filed after his 2016 exoneration by a jury. In that 2016 retrial, Philadelphia jurors deliberated for less than an hour before finding Mr. Wright not guilty. Wright's civil attorney, Peter Neufeld, testified to the grand jury that the exoneration of Wright is the only DNA exoneration in the country where the prosecutor, then DA Seth Williams, elected to retry the case despite overwhelming scientific evidence of innocence. I hope you don't miss that one either. Sometimes Philly outdoes itself, and that is nothing to be proud of. According to the presentment, the three former detectives testified falsely under oath about both the evidence used to convict Wright and their knowledge of the DNA evidence that ultimately exonerated Wright during the 2016 retrial and before they gave their testimony in that retrial. During depositions under oath for Wright's civil rights lawsuit based upon Wright's wrongful conviction, Santiago and Yastrzemski changed their sworn testimony, stating they actually had been told by one of the two trial prosecutors, former Assistant District Attorney Bridget Kern, about the DNA evidence clearing Wright before they got up and testified under oath at the 2016 retrial. At the retrial and depositions, both Devlin and Santiago repeated their false sworn claims that Wright's 1991 confession to the crime had been given willingly and transcribed word for word. After hearing testimony from key witnesses and reviewing evidence, the grand jury recommended that Santiago, Devlin, and Yastrzemski be held accountable for lying under oath to condemn an innocent man and to cover up their wrongdoing, and for perverting the integrity of law. Upon their recommendation, the Philadelphia District Attorney's Office has approved and commenced prosecution for the following charges. Manuel Santiago is charged with 2 counts of perjury, a third-degree felony, and 2 counts of false swearing. That is a second-degree misdemeanor for false testimony regarding the Santiago Devlin confession at the 2016 retrial and 2017 deposition, and 1 count of perjury and 1 count of false swearing for false testimony regarding prior knowledge of the DNA results clearing right at the 2016 retrial. Martin Devlin is charged with 2 counts of perjury and 2 counts of false swearing for false testimony regarding the Santiago Devlin confession at the 2016 retrial and the 2017 deposition. Frank Yastrzemski is charged with 2 counts of perjury and 2 counts of false swearing for false testimony regarding the search of Wright's bedroom at the 2016 retrial and the 2017 deposition, and 1 count of perjury and 1 count of false swearing for false testimony regarding prior knowledge of the DNA results clearing Wright at the 2016 retrial. This is an open and active criminal investigation, and the cases will be tried by the District Attorney's Office Conviction Integrity Unit and Special Investigations Unit. The SIU hotline, that is to say the Special Investigation Unit hotline, 215-686-9608, is available for members of the public who wish to report potential crimes, including official misconduct, directly to my office. I would point out to you that the CIU, which was created in 2018, to date has secured 23 exonerations of 22 people who were wrongfully convicted under prior DA administrations. Investigations of wrongful convictions and exonerations are detailed in a recent accountability report, and that goes to a certain place. But actual accountability is what this is about. Are there any questions, either for Patricia Cummings, who is our chief of our Conviction Integrity Unit, or for me in relation to this matter? Yes, please.
Are you looking at other cases that these detectives were involved in specifically to see if there was similar behavior and whether you need to bring any additional charges?
I have to be very careful in my responses here because I need to make sure that we do not in any way jeopardize anything that is ongoing. And I also want to make sure that, given that we now have pending criminal matters in Philadelphia County headed their way, or I should say headed towards a Philadelphia jury's determination in the future, I need to make sure I don't say anything that might interfere with that prosecution. So if you'll just give me 1 second, I'll speak to Ms. Cummings. What do you think?
Please, sir.
To answer your question, we have spoken previously about the work of the CIU in regard to the kinds of cases we're looking at. And specifically, we had been asked questions several years ago as to whether or not we were looking into potential misconduct, government misconduct committed by some of these detectives. You guys will be familiar. Some of these detectives have been involved in cases not only that we've looked at, but cases that have resulted in exonerations. Just to name a few: Willie Vesey, Walter Ogrod, Andrew Swainson. So because we have been doing this work, we are, of course, always mindful of, are you seeing any kind of pattern of misconduct in other cases? So we've done that. We will continue to do that. I suspect with this announcement, we might hear of some cases that we are not aware of. And certainly our protocol is when somebody writes to the CIU claiming that they're innocent or that they were wrongfully convicted, we will do what we can to take a look at it and determine whether or not the conviction has integrity.
Just to clarify, and I know you may or may not be able to answer this, so does that mean, from what you said, if people can bring you cases and highlight cases that they'd like to see you look at, you are going based on the case or based on the involvement of the detective?
It's really a combination of both, right? So when a CIU gets information that a particular individual might have been engaging in misconduct over the course of years and cases, of course that means it is a flag and it is something that we're going to look at. And you know, we've looked at other cases involving Detective Norda, for example. So yes, we're going to look at the case, but sometimes what happens is when we get information that a particular person involved in that case compromised a conviction in another case, what that may mean is that it raises it up in terms of the priority as far as when the Conviction Integrity Unit would look at it.
Do you have a sense of how many cases you might have to review as a result of this?
Unfortunately, we do not. And so much of that is just a product of, I think, so many different agencies in the city of Philadelphia not having really good records, and certainly not electronic records to where you could do searches and be able to say, these are all the cases that Marty Devlin investigated. And so what we have to do is we have to try to figure out, is there a way that we've got capabilities to identify them, but we also look to other people flagging them for us, and then we look to confirm whether or not there was that person's involvement.
Do you know how many cases so far, how many people's cases so far have been overturned as a result of their involvement?
I'm not going to tell you I know exactly, but I will just once again harken back to, you guys can look at Walter Ogrod's case, for example. You can look at Willie Vesey's case and Andrew Swainson. I think Sean Thomas was another one that they were involved in. And I want to be very careful too when I say they, because what you have is the way that the homicide unit in the police department has worked is they've had squads of detectives. And so sometimes you may have somebody who was assigned to it, but other people working it. So it's not always going to be, are we looking for the combination of Devlin, Santiago, and Jastrzemski? It could be that you have Devlin working with other detectives, just like you could have Santiago working with other detectives.
This might be for the DA. Do you believe these are the only crimes these detectives committed during their time on the force?
I appreciate the question. I'm not smiling because it's not a good question. It's kind of a great question. But there will be a jury that will be selected in the city of Philadelphia to hear this trial. And I think that the expression of my personal opinion at this time might be used by an enterprising defense attorney as a reason to try oh so hard to make sure that a jury other than a Philadelphia jury hears the case. So I will respectfully decline to answer that question.
Did you have any interactions with them as a defense attorney before you became DA? Were you aware of them, or there any potential reputation they might have had in the court system?
You know, certainly I was aware of them from coverage in the media of other cases. You know, for example, the Ogrod case was a very heavily covered case for many, many years. And one of their names comes up in that case. So I was aware of them in that sense. I don't remember, honestly. I don't remember whether I ever did a case involving these detectives.
Could you just speak to what message you think these charges send?
You know, I believe that these charges are an indication that a Philadelphia jury, in this case a grand jury, can carefully look at evidence and can understand that the law must apply equally to people, whether they are in law enforcement or are supposed to be served by law enforcement. But commenting beyond that, given that there will be a Philadelphia jury selected to hear these charges, I think would be unwise from the perspective of a prosecutor's office that is serious about pursuing this case. So I will once again decline.
Did you look at, or are you looking at Carlos Vega or his involvement in that retrial and whether there was any misconduct?
I have no comment on that question.
Why?
What we are announcing today is charges against individuals. I have not brought up Mr. Vega's name, and I think it would be inappropriate for me to do so at this time. Is there any other question?
You mentioned this as an absolute outrage. I mean, the allegations here are incredibly serious. Can you talk about why it is you think detectives would essentially frame an innocent person to send him to prison for life?
So I cannot comment in the context of this case. So what I'm about to say is not about this particular case, but I can tell you that there's a good body of research, which in truth Patricia Cummings knows even better than I do, but it is research I know, which goes to how it is that innocent people get convicted of crimes, how it is that confessions are coerced. And there are many, many examples in the history of criminal justice, one of the most noteworthy being the Central Park Five. Just think about that for a minute. You have 5 different young people who confess to a crime they never committed and never even saw. Not only are the details inconsistent to some extent among these statements, but every statement reflects the beliefs of the detective. Those words do not get on the page by themselves. What you are seeing is the mind of a detective ending up on a page with a signature of a young person who could not possibly have said those things because they didn't even see the crime that occurred. This is nothing new. If we actually look at data that has been produced by the Innocence Project, looking at exonerations all over the country, my understanding is that in about 25 to 30% of all DNA exonerations of homicides, there's a confession. 25 to 30% of them. And in 70% of those cases, you're dealing with there having been an actual identification of that innocent person, whether mistaken or coerced somehow. You're dealing with that. So to me, that is a keyhole into the room, and the room is full of tactics that cause people who haven't even seen a crime, haven't even heard of a victim, don't even know the location to provide all these details. That's a problem. It's a real problem. It is, the impermissible tactics in which prosecutors and police have historically engaged in certain kinds of cases. I am not speaking of this case. But those impermissible tactics are often driven by the intensity of public interest in a case. It is often fed by a media that is telling that story, and I don't say that in any way to be dismissive, but are telling the story of a sensational crime. It is often driven in cases where there is no strong evidence that hasn't been gathered, where there is pressure coming from the police department itself, or maybe a mayor who appointed a police commissioner. There's political pressure coming so that if you can't solve the case, at least you can make it look like you solved the case. Some of the years that we have looked at are years when there was a remarkably high clearance rate, a clearance rate that's still uncorrected. It's years when there were high levels of violence. It was a matter of political and public concern. People's careers were going to be built off of being able to say, we got the bad guy. We locked him up. And, one of the tragedies, of course, is the decades innocent people spent in jail, but the other tragedy is how many of these cases might actually have been solved with the perpetrator being accountable, like Ronnie Bird, but they weren't because people were much too eager to coerce a confession, to lie about where the clothing was found, and to convict pretty much anybody. Is it maybe easier to do this to people who are in marginalized groups? Broke people, black people, brown people? Yeah, maybe it is easier when the person who is being coerced is not of your group, or it does not enjoy status in society, or has no resources to fight back. Maybe that's easier. Maybe it's easier when you have in your own mind just dehumanized people in that category. Maybe that's easier. I think Ms. Cummings may have another comment or two in that regard, having studied this at length. I do want to comment on one thing she said, though, which I think is important. Our sworn obligation to seek justice means that if there's information over here that the defense should get, because the Constitution says so, we should do that. Well, sometimes the process of our looking at cases like this reveals patterns. And those patterns were things we didn't know before, that certain detectives just seem to keep taking confessions from people who didn't do it, and DNA says they didn't do it. Once we see that, our obligation to seek justice really requires us to look at other cases, or we would not be keeping our oath. So yeah, it's an individual case-by-case situation, but when you get to the point where you start to see patterns, as they have, for example, in Chicago, where they saw certain detectives who just kept taking statements from innocent people, that places on us the burden of looking to see whether there's more here. Patricia, did you want to comment further?
Just real briefly. I think in short, for me, the answer is it's hard to say there's ever any one reason why something like this occurs. What we've learned from studying false confessions for the last couple of decades is that human beings that are actually doing the interviewing and interrogation are motivated by so many different things, and Larry just described a bunch of them. I just want to kind of neatly tie it up in a bow and say it's just like most human behavior. You've got all kinds of things on a spectrum. You've got intentional acts on one end, and then on the other end, you have completely unintentional negligent acts. And oftentimes what I think is we see that there may be several things going on at the same time, and we also understand probably more than ever that what affects decision-making for investigators also affects decision-making for prosecutors, and that is biases. We get absolutely totally lost sometimes in terms of what our ethics tell us we're supposed to be doing, which is a search for the truth. And our biases often put us in a position where what we're doing is we're confirming what it is we believe in the first few seconds. And we can't see anything beyond that. And I think it behooves all of us involved in the criminal justice system to do as much as we can to understand those biases, how they affect decision making, and what we can do to guard against them in the future so we don't have additional cases like this.
Did you speak with Anthony Wright before filing this and books?
So I did not. I cannot. Well, let me rephrase that. I have spoken to Anthony Wright. I have not spoken to Anthony Wright in relation to there ever having been a grand jury or these charges at any point, including before this press conference today.
Former DA Seth Williams said he doesn't recall this case.
I'm sorry. Can I hear that again?
Former DA Seth Williams said he doesn't have any individual recollections of this case.
Wow. I don't know quite what to do with that. An incredibly high publicity case that was followed by the entire city of Philadelphia, in which he personally made a decision to do a retrial. He just can't remember it. Well, okay. I guess we'll just have to put that into the credibility hopper for the ex-district attorney of Philadelphia.
Same question I asked you about Carlos Vega. I understand you can answer, but have you looked at or are you looking at any misconduct on the part of Seth Williams?
I have no comment at this time. Is there any other question? All right. Thank you all very much.